When you co-own the property with your kid to avoid the probate process, they will lose the step up in basis on their half of the property. So let's say you purchase a property for $100,000 and then you give them half of that property, making you each 50% owners of that property. Because you purchased it at $100,000, the cost basis is $50,000 for each half. Now, when you go and you pass away and the property is worth $400,000, now each of your halves is worth $200,000. Because they are inheriting your half of the property, they're getting a step up in basis. So your half of the property, it's as if they purchased that property at $200,000 or your half at $200,000. So they won't have to pay any capital gains tax on your side. But on their side, they will owe capital gains tax on $150,000, which would be what their half is currently worth, so $200,000, minus the original purchase price of their half, which is $50,000. So that difference is $150,000. They will owe capital gains tax on that half. And so if you want to set it up as co-ownership to avoid the probate process, you have to make sure you're weighing the financial risk versus reward, because they're going to spend a lot more money in capital gains on the back end versus just paying for a probate attorney on the back end if you did not co-own it with them. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.